Here's another one. Paying for staff training and bringing lawyers up to speed. So staff training, let's talk about this one. This happens in some circumstances more than one would think, where staff, especially on a large case, are essentially learning internal software, many times e-discovery software, but another version is when new attorneys learn their field at the client's expense. There are a number of clients who we work with, for example, that do not believe they should be paying for first-year associates at all. To them, the first-year associate, and I remember what it was like when I was a first-year associate, there were paralegals in the firm I worked with that probably knew a whole lot more than I did. So that whole element of not paying for training, it's an important point. It can make differences in terms of the total cost of your matters. For those of you on the law firm side, this is something to think about as well. When you've got that summer associate, the first-year associate, or law clerk, and they are charging time that might not be as reasonable down the road. Bringing new staff up to speed. This is a real problem on lengthy engagements, primarily litigations. It is common for new staff to be substituted, but what should be exercised in billing judgment, if the firm is doing their job, is not to charge the client for the up-to-speed time. In some of the files that we have seen, this has been an element that has been really right up there front and center. And for those of you who are not watching for it, this is something to watch for. So here's a few case study ideas. If a firm is gearing up to manage large document production, charging the client for internal training, bringing in temp attorneys and contract attorneys, incidentally, and this is just something to think about, there can be serious ethical issues for charging contract attorneys on a for-profit basis. And that's something to really think about. Now, let me say that one more time a different way. If a firm does not have the people to accomplish a very quick and complicated document task of thousands or even hundreds of thousands or millions of pages, what some firms will do is bring in contract attorneys. At that point, there is a division on ethical rules as to how and when the client may be charged. This is, again, its own subject, but I think those of you who are thinking about that now are thinking about the following. Is the contract attorney just a disbursement like an expert, or is it permissible to bring the contract attorney in and then charge a profit for that? The next element is when the firm changes a lead partner in complex litigation. This actually happened in one of the cases I was involved in, where the lead partner changed 3 times in 3 years. Every single time, it became a significant additional expense. So that's the element of training and up to speed. Again, if anyone has any questions, would like to talk about anything we're doing, please do me a favor and type in a chat question and we will address it.